Hi, and welcome to the Law Simplified. I'm Shavin Bandarnayaka. This is, I believe, the seventh live Q&A session that we are having. Thanks ever so much to everyone who's joining us today as well. In the past several weeks, we've completed and done live Q&A sessions for criminal law, for contract law, for public law, as well as several other advanced subjects such as property, trust law, as well as now we are going into jurisprudence. Firstly, just a little bit of context for those of you who are joining us for the first time in relation to one of these live Q&A sessions. The Q&A itself is essentially a series that was started primarily due to the prevailing conditions around the world. As you might be aware, law is a subject that can be prepared for and studied in isolation, so to speak. You are able to prepare for this as well as understand the nuances of the law on your own. However, having said that, law is such a subject that it's always beneficial to have the collective opinions of several people around you. And during this particular time, that's not going to be possible. So, as a solution to that, I decided to allocate this platform in such a way that whatever questions that you may have as students, as academics, as anyone who's interested in the law could have a point of interaction where we could have live discussions back and forth. In fact, more than any other subject, if you take the subject of jurisprudence itself, I think this requires a lot of argument and a lot of discussions by and large. Right. Now, just a little bit of a outline. If you have any questions that you want to ask in relation to jurisprudence, or for that matter, as I've come to understand, in relation to other topics as well in the previous live Q&As, there have been so many students asking other questions as well. It doesn't matter whatsoever. Whichever question that you have, make sure you use the live Q&A, the live chat box rather, that's on this particular YouTube live stream itself. And the way that these particular live Q&As are structured is essentially we would go through what I like to consider as a fast track theory, where we don't go deep into each individual topic per se, because jurisprudence in itself is a wide gamut based subject, and because of that it would take a month of Sundays essentially to go through this particular subject matter. For that, I do have my pre-recorded masterclass and fast track programs available on my online law school platform, as well as I do conduct one-on-one sessions as well. So if you check some of the description, some of the links in the description below, you'll be able to reach out on those. But what these sessions are meant to do is, on the one hand, for me to give you a very broad stroke overview of a way in which to think and structure yourselves in relation to this particular subject, and then go through any particular questions that you might have. Right. Having said that, how we are going to go about this is, as I've just mentioned, we're going to go through a fast track Q&A, fast track theory rather, where I'll look at the different aspects of jurisprudence, how to think about it in the first place, and how to enrich your responses, so to speak, when you look at a question that is presented to you. Now, I do see that there's several concurrent viewers that are joining in, so let's give it a minute or so, and then we'll begin with the fast track theory in itself. A quick outline once again, just before we proceed. Do use the live chat box. Make sure you put down any questions that you might have in relation to the subject at large, any particular topic as well, or even an argumentative point that we can go through. I think that we have sufficient concurrent viewers as well, so we can start going through it. Now, by and large, to begin with, jurisprudence is not essentially the same as any other subject that you would prepare for in law. The reason why I say this is because whatever subject that you're preparing for, it can be criminal, it can be contract, it can be a bit more theoretical topics like public law, it might be something very operational like tort law or property law, very procedural in that. All of these subjects relate to a particular area of law itself. What I mean by that is, When you look at these subjects, for example, let's say contract law, it deals with the formation, operation, and discharge and whatever breach they are in as it relates to a contractual arrangement between parties. When we look at criminal law, it might be the laws imposed by virtue of the state on the citizen and what punishments are going to accrue to that defendant or the assailant in relation to whatever the law that has been broken. When it comes to property law, it may relate to something like the conveyances that take place, essentially by looking at whether certain benefits and burdens pass on, whether registration has taken place, or for that matter, whether registration is required in the first place. However, when we look at jurisprudence by and large, jurisprudence doesn't relate to the law itself. It relates, on the one hand, to the ways in which we need to think about the law, and on the other hand, it invites us to argue and put ourselves into a particular gamut, or let's say a bucket, so to speak, in terms of our understanding and our ideas. No matter how objective that we may think we are, jurisprudence is the type of subject that actually takes out our innermost feelings and thoughts about the law, about people, about society, what is right, what's wrong, what's moral, what's immoral, what should be legal and what should not. So because of this, when we take the whole of jurisprudence, it's an ocean in itself if you really think about the type of areas that you will have to look at. The type of jurists that you might have to consider, the types of theories and the types of arguments that are presented. That being said, because of this, what I felt most important to any jurisprudential student or anyone who's going into or getting into this subject is to put everything that you will study into a broad stroke context. And one of the major ways in which you can have this context built up is to look at and consider whatever that you learn in relation to two specific categories, two limbs essentially. Now, on screen now you'll see probably several schools of thought, several jurisprudential thinking methodologies that you might have come across and that you might be familiar with. From natural law to positivism to the extensions in pure theory, sociological thinking, Marxism, liberalism, feminism, and so on. Now, as a whole, when you look at all of these theories, let's call them, or what thinkers have essentially professed or espoused to the mass, generally speaking, at first they all will look the same. But in reality, how I prefer to consider it and how I would argue and suggest to you as well is to firstly put these into two buckets. One, in relation to actual thinking, the ways in which different jurists have thought about the law itself. And on the other, as movements. Various thinkers have, across the board, across different planes of time, have essentially suggested jurisprudential thinking as a means to an end. We have seen movements over time that have been essentially stemmed from different jurists and thinkers. So if we take this as our starting point, you'll notice that thinking patterns or other schools of thought such as natural law, its progression into positivism, and even sociological thinking falls into that category itself. Those are ways in which different jurists and academics have suggested to us in relation to how to think about the law, how we should manifestly argue as to how the law itself has been applied in different circumstances around the world. On the other hand, if you look at something along the lines of Marxism or liberalism or even feminism for that matter, these by and large, more so than really ways in which to think about the law or the way in which society is structured, essentially dive deeper into movements themselves. These are calls to action, so to speak, that different thinkers and jurists have manifestly provided us. A good example here is Marxism. Karl Marx himself has been very earnestly and popularly considered to have said that jurisprudential thinking is not just the mere discussion of different types of laws and how we should think about the law, but it's meant to be a metric and a mechanism and a tool by which we can change the world. And most of these movements that we speak about, from liberalism to feminism to that of Marxism, the origin point in itself, essentially looks at this. These are movements. Right. Now, that being said, considering this first distinction as being the difference between different schools of thinking as amounting to thinking itself, and on the other hand, movements, a means or a causal action or a means to an end, so to speak, the next major distinction that we need to understand and make is in relation to how to think pragmatically about these different schools of thought. Now, one common mistake or one common misinterpretation that I've noticed that many students make is in relation to the fact that they look at different schools of thought, such as natural law or positivism or Marxism or whatever it might be, and they consider it to be sequential in nature. What I mean by that is, more often than not, many students will look at a particular country or look at a particular jurisdiction and the way in which the government or a state is run, and then determine, okay, this looks a lot like natural law. Or they might look at a particular period of time and then say, during this particular time, it's clear that it was mostly positivism or pure theory that was manifestly in operation. But a better way to consider it, and a way in which that you can apply the law in a much more objective as well as a philosophical and an argumentative level, is to actually look at and consider jurisprudential thinking as being quite relative. Now, what do I mean by relativity here? Generally speaking, think about the different schools of thought, from natural law to Marxism to pure theory and positivism, having been applied to different jurisdictions on the one hand, during different times, and even in the context of a country, different departments, different stages, or different purposes looking at jurisprudence in different ways. Now, by this, what I am considering or what I am suggesting to you is to look at the different jurisprudential ideologies as falling within a plane, either horizontal and a vertical axis, so to speak. By doing so, the idea then that is created is that you won't have a particular jurisdiction that's only run by natural law, for example, or positivism, or Marxism, or liberalism. Rather, you will start to notice that the use case for these different schools of thought depend on the place you are, in relation to what you're talking about. Is it healthcare? Is it education? Is it access to justice? And based on the time it is being considered. It might be today, it might be 10 years from now, 10 years in the future. Everything is relative. It depends on a number of different factors. It's not one-dimensional, it's multidimensional in that context. Right. So this, by and large, is the first level in which we need to start thinking about jurisprudence. As an entirety of a subject, once again, it is not about any specific law as such, rather it is about how you need to look at the law at large. When we consider this notion, when we consider the law at large, what we are really considering and looking at is based on what exactly the jurisprudential thinker was hoping to do with it. It is in his mind's eye when he developed this particular ideology. Is it merely a way to consider what's happening around you, much like in natural law or positivism, or is it a mechanism, is it a manifesto, so to speak, to get to the end, or a causal link to as a means to an end, like Marxism or feminism or liberalism? Many civil rights movements around the world in the past have benefited and leveraged on jurisprudential thinking on its own by means of couching it, so to speak, in the format of movements. Right. Now, having said that, once again, jurisprudence in this context, in this live Q&A, I wanted to spend a little bit of time not essentially going through in depth of each individual jurisprudential metric, or rather the school of thought. there's plenty of content out there for that on this very channel itself. Do check out the playlist for jurisprudence on the Law Simplified channel, as well as the mini courses, the pre-recorded fast track and masterclasses available on the online law school platform, which you can access through the links in the description, as well as by going straight to courses.thelawsimplified.com. Right. Now, having spent quite a number of minutes in relation to our limited time on the live Q&A, looking at jurisprudence in a very high level, let's say, in an articulate manner, I think it's good to have a look at some of the questions that have come in as well, and there's quite a few that have come in. Let me just try to have a look at the questions being presented. 1 second. Here we go. Okay, so there's quite a number of questions that have been posed on the live chat as well. I'll try to go through as much as I possibly can within the time frame that we have. Okay, so we have Bimasen, is it? Yes. How can we define Aristotle? That's a bit of a loaded question in the context that I have to determine what you are essentially trying to get at, Bimasen. But if I am to consider your question in the context of who is Aristotle, he is one of the forefathers of jurisprudential thinking, along with Plato and Socrates. If I am to put him into the context of different jurisprudential thinkers and where exactly he fits in the grander scheme of things, he would fit as one of the classical thinkers in terms of natural law. What he and his contemporaries from Socrates as well as Plato had prophesied, or rather communicated, was that whatever laws that have been manifestly considered as being brought down from above or from a greater higher authority must be then applied to with reasoning before determining whether to follow it or not, whether to apply it or not, and so on. Aristotle is one of the forefathers, so to speak, in jurisprudential thinking. I hope that answers that question. As I noted earlier as well, I suppose there are a few questions outside of topic as well, but nevertheless, Raja Lakshmi, there is a question. Could you tell us how to prepare an outline while preparing for the law exams? Okay, so again, there's limited information here, Raja Lakshmi, for me to determine what you mean by an outline here. But from what I gather, what you're referring to here is how perhaps to summarize and to bring your thoughts into a place where you can take the content that you've learned over time and apply it into, let's say, an examination, or to have it in such a way that you can make better sense, so to speak, when you sit for the exam. One way in which that I have tried to illustrate on a number of occasions on this very channel, as well as to showcase on my mini courses also, is that it's all about trying to not necessarily memorize, but to theorize and to understand what you're going through. And one way to do that is to try and summarize as much as possible the content that you're learning into smaller and smaller units of notes, until you get to a point where it's on a very basic level, on a fundamental level, when you look at it as a stranger, but it makes perfect sense because you're the one that has brought that note down from a much bigger note into, let's say, a page or so. That's one way to go about it. The way that I used to prepare outlines, or the way that I used to prepare for examinations and studying at large, was I would write down a lot of notes in relation to whatever the topic that was being studied, followed by converting it into a double-sided A4 sheet, making that into a double-sided A5 sheet, which is half the size of an A4, and then that being converted into the spider graphs that you might see littered around the YouTube channel as well as my courses. So by the time you get to the spider graph level, the outcome is that you've already repeated what you've written a number of times. You've gone through it about 4 different levels, and the spider graph will technically make sense to you since you're the one that has brought about it. But one major mistake that I do see in students is they tend to try and cram everything they know into a spider graph. That defeats the purpose. The idea of a mind map or a spider graph or a short note is in fact that it should be short. It's not about trying to cram as much into one page, rather trying to summarize it in a way that it clicks, so to speak. I hope that clears it, Raja Lakshmi. Okay, Maria has a question. Why are there more normative or prescriptive perspectives on human rights than sociological and empirical perspectives? This is a much longer subject area, Maria, but there is a very simple answer to that. It's the ubiquity of it. So what I mean by that is, if you notice the different perspectives of human rights trying to be applied, so to speak, in different places, much like jurisprudence, it in itself is also very relative. While you do have, for example, a certain subset of rights which can amount to being universal in nature, like right to life, freedom of expression, freedom of religion, freedom from torture, things of that nature, you might also require specialties and different specifics that are to be applied across the board depending on the jurisdiction, depending on the society, the people, and so on. So having that in mind, it's very difficult to have a much more higher level of thinking, so to speak, that trickles down, like a set of rules as such. So because of that, you do see more of a tendency of it being more prescriptive in nature than there being some sort of perspective that is wide in nature. But it is a larger area, and human rights is something that cuts across a number of subjects as well, if you really think about it in law, from public law to administrative law to human rights in itself, to jurisprudence. So it's a far larger area. I hope that covers it for now, Maria. Okay, what are the general principles of public international law? Again, larger area. I think I will leave that aside for a bit for two reasons, mind you. One, Menka, is that at the moment I do not offer public international law as a course, while I do offer private international law, which is conflict of laws. It's essentially two areas which do not oppose each other. There are areas in which it overlaps, but it will be incorrect of me to advise you on anything in relation to public international law when I don't in fact offer it as a subject. Okay, so Matthias, I'm not really sure about the question that you're asking, whether it's in relation to the choice between criminal law, constitutional law, or the interconnection. If you can clarify that a bit more, I'll be able to answer that. Okay, the right theory is the theory of instincts, meaning that there is no natural law or positive law that people do things instinctively like animals. What do you think about this? First and foremost, wonderful profile name, billionaire quote. Having said that, this is an interesting idea. In fact, this is not an alien idea as well, because if you think about, for example, the school of thinking professed by Savigny, Frederick von Savigny, the historical school of thinking, actually looks at it in this way somewhat. Although I think what you mean here by instinct is essentially the gut feeling, so to speak. Savigny essentially talks about this idea of evolution, that things essentially happen by virtue of evolution. It's just happening over time. But similarly, for example, you can think of social pressures, or the mantra that has been professed by H.L.A. Hart as someone who tried to bridge the gap in positivism from going too extreme, like it did in terms of pure theory, for example, in terms of Hans Kelsen. So in relation to that, when you really think about the aspect of instinct, you can either look at, on the one hand, Savigny's historical school of thinking, or HLA Hart when he speaks about, or when he talks about the fact that laws will be followed based on social pressures and social norms. People doing things primarily because everyone else around them is doing it, and as such, it being a bit it being not necessarily forced on people, rather people following it by virtue of everyone else following it. So I believe that thinking here, in the sense of what you're suggesting, people do things instinctively like animals, that connects to the concept or the context of instinct. I believe I have missed one question. I apologize, Sanchit, I believe. Do you agree with Henry Maine that the credit for genesis of jurisprudence goes to Roman period? To be fair, I'm a bit objective on that, Sanchit. The reason being, it goes back to the concept that I spoke about earlier in the fast track theory component. When we talk about jurisprudence, and the reason why I'm saying this also is because the way I look at jurisprudence is somewhat skewed and different from many others. So for me, jurisprudence is not essentially a sequence of events that started somewhere and end somewhere. To me, it's more like, to be fair, it's more like a collection that gets built upon. So if you think of, for example, the more common perception that Jeremy Bentham is essentially the father of jurisprudence. He's considered as such. The reason why we say that is, and most students and most academics tend to drop this particular adjective, is the father of modern jurisprudence, the way we have understood jurisprudence as it is. But do I believe that a particular person can be accredited with jurisprudence as a whole, as a subject matter? No, because everyone has added, to some extent, their own variety or flavor, so to speak, of this particular subject matter. I hope that clarifies it somewhat. Correct. Yes. There is. So when you're taking it sequentially. So from my perspective, I prefer not to take it sequentially. I prefer to take it in the context of having different aspects of law fulfilling different notions. For example, each individual will have, no matter how objective they are, some sort of affinity as it relates to, let's say, for instance, natural law. They might feel, in a certain sense, that they want natural law in a certain way. For example, if we take the current pandemic situation, you might see certain countries affecting lockdowns or curfews or complete closures of things in a very direct manner. I mean, it's forceful as such. Whereas others will try to keep the law as it is and provide guidance. So which law, or rather which jurisprudential thinking has been applied in different jurisdictions differ. That's what I'm trying to get at. It's very difficult to look at it sequentially. You'll have to look at the circumstance, you'll have to look at the interests, as well as what benefits are provided, essentially. I'm going to go on to a few other questions, Sanchit, and then I'll get back. Okay, so I think what Matthias asked earlier is in relation to the specialization. So based on what you asked earlier in relation to constitutional law or criminal law, by and large, if you're doing your first degree, you necessarily don't have a choice. If you're looking at what area of law to get into, essentially, as you move on, that would relate to career-wise what you would want to get into yourself, Matthias. So, for example, if you're going into criminal law, I would argue that it's good to supplement that with things that will aid you in that later on, both in your first degree as well as in your postgraduate, such as evidence, civil and criminal procedure, criminology, things like that. It's really about gut feeling at this point, unless you have a specific area that you want to go into. Maria asks again, what metaphors are explained in the COVID-19 pandemic and how did they impact on the approach that is being considered from public health? So once again, I think this relates to the example that I just gave you as well. It really depends on that relative context of where you're talking about in terms of jurisdiction and in relation to what aspect of society. So for example, you have narrowed down the area of public health as being the area in itself. So because of that, public health, for example, as it relates to the African continent or the Asian continent or North America or Europe, so wholly different. So you might have, for example, in Asian countries where certain jurisdictions, certain governments are much more forceful in enforcing, in a literal context, disease and quarantine ordinances or laws. You'll notice that it's very pure theory-like, very Kelsen-like. You might have countries like North America or Europe where I wouldn't call it pragmatic as such, but the approach might not be in that context. It's much more sociological, much more like Pound, much more like Roscoe Pound. Based on the need of the hour, certain things happen. So closures happen sequentially, or rather closures happen based on the need of the hour at that time, rather than across the board. So again, Maria, it really depends relatively. And this is actually a good point for me to stress on what I've been saying throughout today's lesson as well, and in my fast track and masterclass courses as well. Don't take jurisprudence in isolation. Don't take the different schools of thinking in isolation either. You will see overlaps, you will see gaps, and you will see implementations, for example, in the same jurisdiction, differentiated by virtue of the areas within that society that you're talking about. Healthcare might implement a certain type of jurisprudential thinking, whereas education another, commerce another, labor another, and so on. So don't track yourself as such. Don't tunnel vision into one path and say this particular country or this society is in this particular manner. That's like the major thing that I can allude to, essentially. Yes, I do want to make this series, this live Q&A sessions, much more interactive as well. And I've been experimenting with having a few of my students, as well as those who are online on live Q&A sessions themselves, be a bit more hands-on. So over the next couple of weeks, I'm attempting to expand on this series as well. So hopefully, as Sanchit has suggested, it will be better to discuss in a much more interactive manner. Right, I hope I have addressed as many questions as possible. We are limited by time as much as in terms of the content that we can discuss. There will be several other masterclasses and fast track courses available on my online learning platform, on the online law school, so do check it out. And you can check out comprehensive courses through the links in the description below. But having said that, thank you ever so much once again for joining in relation to this particular live Q&A session for jurisprudence. I hope it was helpful for all of y'all, and thank you again for being part of the Law Simplified family, and do subscribe to the Law Simplified channel as well. Having said that, have fun, stay safe, and as always, obey the law. Cheers.